But we begin tonight with a wild day in court in Fulton County, Georgia, as we learn the source of the leaked confidential interviews between DA Fani Willis's office and some key figures in her January 6th RICO case. Fulton County Judge Scott McAfee said he'd issue a protective order in the case, barring disclosure of certain information from the discovery process, one that would allow some evidence from the pretrial discovery process to be labeled sensitive and withheld from public scrutiny. The videos obtained by ABC News and the Washington Post showed interviews with witnesses Jenna Ellis, Sidney Powell, Scott Hall, and with Kenneth Chesborough, whose video was not released publicly. All have taken plea deals to flip on Donald Trump, and the release prompted today's emergency hearing. At that hearing, there was a surprise confession from the source, Jonathan Miller, the attorney for one of Donald Trump's 18 other co-defendants. Former Coffee County election supervisor Misty Hampton.
In being transparent with the court and to make sure that nobody else gets blamed for what happened, and so that I can go to sleep well tonight, Judge, I did release those videos to one outlet, and in all candor to the court, I need the court to know that.
Attorney Mitchell's explanation was that hiding the videos would, in his words, mislead the public about what went into the 4 guilty pleas, adding that he believed it would help his client, saying that 2 of the defendants were directly related to my client. Mitchell did not say who those 2 clients might be, but his client, Misty Hampton, is charged along with Powell and Hall in a scheme to access voting machines in Coffee County. Meanwhile, Fani Willis also sought to revoke the bond of another of Trump's co-defendants, Harrison Floyd, the former head of Black Voices for Trump, citing a pattern of intimidation toward co-defendants and witnesses, noting that Floyd engaged in numerous intentional and flagrant violations of his bond agreement. Those violations include recent tweets tagging individuals like Georgia Secretary of State Brad Raffensperger and former Fulton County elections worker Ruby Freeman. Joining me now is Barbara McQuade, former U.S. attorney and law professor at the University of Michigan, and Lisa Rubin, MSNBC legal analyst. Thank you, ladies. Lisa, I do want to start with you because it strikes me that in this last case, the case of this attempt to revoke the bond of this defendant who was involved in the attempt to intimidate Ruby Freeman in the first place, Harrison Floyd. Interesting that he is now looking at having his bond revoked and could wind up in jail. That is not something that Donald Trump has faced, even though he, too, has intimidated witnesses. Did that come up? Did his lawyers bring that up in this case? Because it's interesting that he's doing what Donald Trump is doing, but not facing the same, freedom to move.
So, Joy, this motion was filed after today's hearing, and so I'm not aware that anybody addressed what conduct Donald Trump has engaged in that might, for example, violate his own conditions of release vis-a-vis the other Fulton County defendants and witnesses. That having been said, the Fulton County DA lays out a number of acts over the last 2 weeks in particular, between November 1st and November 14th, where Harrison Floyd, as you noted, has gone after a number of his co-defendants or witnesses, in particular, really attacking Jenna Ellis. And I'm looking at one of the tweets right now, 2 days ago, saying that she was lying on Dan Scavino. And I guess they don't teach ethics at Harvard Law anymore. As an aside, Jenna Ellis did not go to Harvard Law School. But the larger point is that Harrison Floyd has engaged in a 2-week-long campaign to intimidate and fight back against people involved in this case, ranging from Brad Raffensperger and Gabe Sterling, as you noted, to Jenna Ellis and Sidney Powell. And then finally, the motion ends with a litany of his tweets aimed squarely at Ruby Freeman, who is the person that he victimized in the first place, leading to the charges against him, and who he continues to victimize and was probably the most offensive conduct that he engaged in, according to DA Fani Willis's team. So I look forward to seeing how this motion is litigated, but this is just the opening salvo that we have here right now, Joy.
Barb, can you comment on this? Because, I mean, the thing is that Donald Trump, the problem with his behavior is that it is infectious, that other people who are MAGA think that they can do what he can do. But he was a former president of the United States. He's not a black guy who was the head of Black Voices for Trump. this guy's already been jailed for his previous conduct that was violent-ish, and he was the one who was in jail, the only one who was actually jailed prior to his plea. He's now attacking the same person he's accused of intimidating, bullying her again, continuing to victimize her. It's a wonder he hasn't already been put back in jail. However, there is a discrepancy between the kind of bullying that he can do. He probably doesn't have 25 million or however many followers that Donald Trump used to have on Twitter, or however many he has on Truth Social. Trump can actually direct a mob at people. This guy can't. But can you just address the discrepancy in the sanctions that both of them face? I mean, it's obvious he's not the former president, so he doesn't have Secret Service, but come on.
Yes. So, in this case, and the Georgia RICO case, there is not currently any sort of gag order like the one that we've seen in the federal election interference case or the one in New York. So that's not what the concern is here. One of his bond conditions is that he not communicate about the case with any of his co-defendants or witnesses. And so I think this conduct directed directly toward Ruby Freeman is particularly problematic with that bond condition. As we just heard from Lisa, she was the direct victim. He tried to intimidate her and coerce her into confessing falsely that she had violated and committed fraud in the election, when, of course, that wasn't true at all. And so that sort of intimidation, it goes to the very heart of this case. So I don't imagine that at the very first instance, the judge's first instinct will be to cancel his bond and put him in jail. But I think it's important that the judge send a message that he takes these conditions very seriously. And so I imagine we will see him in court with at least a warning, and a second violation may land him in jail. And of course, as you point out, Donald Trump says all kinds of things about people, including about people who might be witnesses or might be co-defendants. And so it seems that it's Fani Willis who's giving him a slightly longer leash. And I imagine part of that is because as a candidate for president in the future, judges are likely to be inclined to give him a little more leeway so that he can respond in the public arena to these charges against him. But I think you raise a good point about treating like people alike. And I think Fani Willis has to be careful not to be seen as holding herself to double standards.
Let's talk about Donald Trump, his team moving for a mistrial. Let me read some of what his proffer is trying to get a mistrial. It's so many cases, it's hard to keep them straight at this point. Lisa, I'm going to leave it to you to explain more. Here's what he wrote in this case. The evidence of apparent and actual bias. I think this is in his New York case. This is his New York case, which he's already lost. It's tangible and overwhelming. Such evidence, coupled with an unprecedented departure from standard judicial procedure, has tainted these proceedings, and a mistrial is warranted. Let me add another thing. He's also gone after the law clerk, saying that this is the other piece of his proffer. It's saying the law clerk has no constitutional authority to act as a co-judge, and the impropriety of her participation is further magnified by the fact that she has violated a separate canon of ethics by making partisan political contributions in excess of strict limits, including to organizations actively supporting Attorney General James and opposing Donald Trump. Can you talk about that just a little bit, Lisa, this attempt to try to throw out a case that is already kind of decided?
Yeah, it's interesting, Joyce, because, to your point, when you say it's already kind of decided, this is something that I am trying to make clear to our viewers whenever I have an opportunity to comment on this case. The judge did decide that there has been a pervasive and years-long fraud engaged in by the Trump Organization and the 5 individual defendants with respect to how Donald Trump valued his assets. But there are 6 remaining claims here. That's why we're still having a trial that I have been attending fairly regularly. And each of those claims require proof of intent by the defendants. And that is why they are as contested as they are, and they will take as long to try as they will. Those claims are also important to the Attorney General because the magnitude of the relief that she is fighting for will largely turn on how they are able to show intent by Donald Trump, his adult sons, Alan Weisselberg, the former CFO, Jeff McConney, who was the former controller, and then the organization as a whole. So the case is very much still alive. Now, to your question about the principal law clerk and the judge, the allegation that Donald Trump's lawyers are making is that this judge is functioning effectively as a co-judge and that nobody elected her, that she exchanges notes and constant whispers with Judge Arthur Engoron that lead them to believe that she is exercising a level of authority that is inappropriate. And on top of that, because of her partisan political contributions and activities, that she is already a person who's demonstrated a partisan prejudgment of Donald Trump before she ever walked in the room. I think that to the extent that they are able to show that her campaign contributions are problematic and are a violation of judicial ethics here in New York, that will not be a basis for a mistrial or overturning any later decision by Judge Engoron. It will likely be, if proven, a basis for discipline. And as you know, Congresswoman Elise Stefanik has a pending complaint with the New York Commission on Judicial Ethics. But there isn't a lot of proof that the conversations between the judge and his law clerk are, in fact, emblematic of bias. As Barb knows well, just because you lose repeatedly in front of a judge doesn't mean that judge is biased. It might mean that you actually committed the conduct of which you've been accused and might be held liable in the future.